Hey out there, legal warriors. Everybody needs to know this, even if they've yet to ever be charged with a crime. I hope you never are. But it's really important that we know how a criminal case starts in the system in case we're ever accused or anyone we know is being accused of a crime. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. By putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. It's really confusing how crimes are initiated, the prosecution of crimes, that is, are initiated in Washington State. And in this video, I'm going to cover how that works. And there's several different categories of situations that make it different how a crime is initiated. And that is why it can be so confusing for any loved one, if someone's been arrested, or for yourself, if an officer's made contact with you, you're like, where's my court date? What's going to happen? Am I going to be charged? So this is how it works. And these are the different categories. So let's first talk about a misdemeanor charge. A misdemeanor charge within the city limits of a city. Basically, there's differences in what happens with how a case is initiated based upon the type of charge, felony or non-felony, that is felony or misdemeanor, and also the type of law enforcement agency involved. Is it a state agency like the state patrol or a sheriff? Or is it a city agency like the municipal police, city of Linwood, city of Oak Harbor, city of Seattle, et cetera, et cetera. So in a city case for a non-felony like a DUI, assault, or theft, what happens mainly is the officer will write out a criminal citation, an 8x11 piece of paper, now done by computer, that's really hard to read, but they can file their own criminal citation into court. So in that case, there's going to be a cause number at the top of the citation. Usually for 2023, it would be 3A something. For 2024, it would be 4A something, that type of stuff. And they file it in the court. And they usually give a copy of the citation to the offender, but not always. Often, sometimes they don't. So what happens with that citation, that criminal citation, when the court gets it? Well, when the court gets it, there's going to be a member of the court staff, who is going to enter that citation into the computer. And at that point, there's a record of the charge in the court. Once that citation is entered into the computer, the clerk is going to generate an arraignment date. That's a date where the defendant, the person who has been cited, needs to come to court. And typically then a summons will be mailed from the court to the address the officer took down for the defendant, telling the defendant to come to court for an arraignment. Now, if it's a DUI or a domestic violence, there may be an actual date and time at the top of the citation, the very top left, telling the offender when they need to go to court. So in a city case for a non-felony, that police officer does have the authority to file their own paperwork into court that actually charges someone and sets an arraignment date, accuses someone formally of a crime that does not need to be countersigned by a prosecuting attorney. So if you get pulled over by a city police officer, you're going to have court pretty quickly if it's not for a felony. If you're pulled over by a state police officer, think state patrol or sheriff, for a non-felony, it's going to work totally differently how they initiate a case. So I'll cover that next. How is a case initiated for a county officer? You're on the interstate, so therefore you're pulled over by state patrol. You're on a highway, you're pulled over by sheriff. You live in an unincorporated area. That is, let's say you live in Everett, but it's outside of the incorporated city limits of Everett. Your address might say Everett, but you actually live not in the city of Everett, in the county. Therefore, the sheriff responds. Same way for other counties if you're outside the city limits. How does that work? In that case, the officer is only empowered to make an arrest for investigation of a crime. They're not allowed to file their own citation into court like a city police officer is. And I think the reason why is their jurisdiction is so broad, they would sort of get it wrong. And so the prosecutors don't want them to do that. Okay. Instead, what happens is if they arrest you, then the defendant goes to court. If it's a county case, a non-felony county case, and this is, I get this call, I got 2 this weekend, you're not charged with a crime yet. Let's say you got arrested on I-90, and it was for a DUI, and you get put in the jail. It's the state patrol that arrested you because you're on Interstate 90. What happens? Are you charged with a crime yet? No, you're not officially charged, but you are arrested for investigation, and the court has power to set conditions on you. The court can hold conditions on an uncharged but arrested suspect for up to 3 days. And the conditions might be post bail or don't have any contact with your loved one if it's a domestic violence case. It could be put an interlock in your car. It could be stay away from certain areas, don't drink, those type of things. And what happens is the prosecutor in that case has 3 days to decide whether or not to rush file the charge and maintain those conditions on you. In most situations for non-felonies, a prosecutor will not rush file a charge, and therefore those conditions that can only be held on an arrested but uncharged defendant, they can only last for 3 days, so those conditions get dismissed. And that is a big state of confusion for people. They hear their charge is dismissed and they think they're done. You're not done. Yeah, I've got at least 5 videos on my station about this. If it's a county officer and you're arrested and you're not charged within 3 days, it doesn't mean you're not going to get charged. It just means it's going through the normal process. So let's cover the normal process. If you're arrested and you're not charged within 3 days, it goes to the county prosecutor again to make a charging decision. Also, if you're just investigated and not arrested, sometimes the officers say we're going to refer it to the county. What that means, again, it's going to the county prosecutor to make a decision. So how does that work? I want to go over how it physically works so you out there can think and understand the physical steps that have to happen so you'll have a better idea what's happening in your case. So the county prosecutor is an attorney, someone who went to law school, and there's a bunch of prosecutors that work for their office, a bunch of people that are attorneys, and it's their job to, since they have a job prosecuting, is to prosecute the cases brought to them by the police. Okay. And so, I used to be a prosecutor for 7 years. So you get to a certain case in the file, a case in your pile of cases as the prosecutor, and then you read it. And then they go, yeah, I think I'm going to charge this suspect with, let's say, DUI. So what happens next? Now it looks a little bit like what happens with the police officer in the earlier case. The police officer files their own complaint, a big old citation, 8x11 on their computer in the car. What the prosecutor does is they draft a criminal complaint, right? It says, I accuse defendant of DUI on this date under this law, 4661-502 in this case. And then they take it and they sign it. So there, the prosecutor has to sign the complaint. Then what happens? Well, the prosecutor chooses what court to file the complaint in. In most counties, the prosecutor has several options where to file the charge. It might be based upon where it happened. It might be based upon caseloads. It could be based upon any reason they want. So they take that criminal complaint and they file it in the court. Now, at this point, once the court clerk gets it, they're going to generate a brand new case number, a court case number, and they're going to type it in the computer. At that point, once it's typed in their computer, us defense attorneys can see it. Now, you and the public may or may not be able to see it. It depends what court it's in. In King County District Court, you'd likely be able to see it by typing in your name. In Seattle Municipal Court, you could see it by looking at a portal. But in many counties, you would not be able to see it yourself. Now, once it gets typed into the system, again, an arraignment date is going to be generated. An arraignment is that first court date where we plead not guilty. That arraignment date has to be set within 14 days of the complaint being filed, or it affects some speedy trial rules. Nothing you need to worry about, but your lawyer would. Once that complaint is generated, they're going to mail that summons. What's a summons? It's something telling you to come to court for an arraignment. Now, what often happens is maybe you missed the summons. It's been a year since the thing happened. You moved, or they never took your address down. And so, if you miss your summons and you don't appear for court, you're going to get a warrant for your arrest. That's why sometimes you want to hire an attorney, or most of the time, you should hire an attorney prior to that court case being actually filed in court, not only to help your defense, but so someone can be watching those attorney only systems to see if there's a court date. That way, you don't miss a court date while you're traveling, or just because there's a bad mail situation or a bad address situation. So that's how a non felony works for county cases. Again, it's not the officer writing the charge into court, it's a prosecutor who eventually gets around to writing the charge into court. And why is that a big difference? Well, because the prosecutor doesn't have to file every case, right? The prosecutor might look at this domestic violence case and it might look pretty weak, and maybe they talk to their alleged victim. The alleged victim doesn't want to proceed, or they can't find the alleged victim, and so now they just don't file it. So what's that mean, Lance? Do I know they're not charging me with the crime? No, you don't know. They don't send a notice to you, defendant or suspect, that they're not charging a crime. So again, another reason you might want an attorney, because the attorney can use some back channels to try to find out, are you charged, or was the case declined, right? Is it still under review, or was the case declined and now you can rest easy? I just called a client last week to tell them that their case was declined, a very serious case that the prosecutor's not going to pursue. If we didn't find that out for the client, they would go the rest of their life not knowing, because some cases don't have statutes of limitations. They can take as long as they want. So what happens for a felony then, Lance? What if I'm in the city and they accuse me of a felony assault, felony eluding, drug possession, lots of different things, something with a gun? Can the city police officer just arrest me and cite me like they do for a non-felony? The answer is no. For the felony type cases, it's pretty much all the same. An officer could only arrest, they cannot charge. Then we go back to that first appearance stuff. Once we're arrested, we have, for a felony, we have a first appearance. That's going to be a court date where the judge will be asked to set a bail, because a felony is so serious. You might have to post a bail to get out of jail. It could be 10,000, could be 200,000. And there's a chance for an attorney, usually the public defender, to argue about the bail. And then there may be a second appearance set the next court day or 2 court days later to try to determine whether or not that prosecutor's office is going to rush file the charge to maintain that bail or maintain those conditions. Remember, if they do not rush file the charge, they're going to dismiss the case against you, though it's not really dismissing the case, it's dismissing that probable cause hold. That case is still there, and it's going to still be reviewed, and it's likely still going to be charged. Now, I talked about the first appearance. That's where there's a bail set and conditions are set. Some counties have an official second appearance. Like in King County, you're going to have a second appearance either the next day or 2 days later, usually at 2:30 p.m., to determine whether or not you've been rush filed on, or whether or not they're going to take their time and decide whether to charge or not. And that, again, you'll see a dismissal of your case, but your case is not dismissed. It's the probable cause hold that's dismissed. In other counties, like Snohomish County, they don't set a formal date for a second appearance. They give you a piece of paper that just says, hey, come back. If charges aren't filed by this time on this date, these conditions are dismissed. Although they don't tell you how to figure that out. Isn't that nice? Usually us attorneys have to do that. So again, in a felony, the prosecutor, if they're going to file it, they don't file a complaint. They file an information. They call it something different, but it has the same effect. It goes to the court enters in the computer, then we can see it. The court sends out a summons to you telling you to go to court, and then you have to go to court again for arraignment to plead not guilty, and the whole court process starts again. So these are dealing with crimes. If you had a traffic ticket, which is not a crime, then they just give you the ticket and they file it into court. But for crimes, it's important. You need to know 2 things. You need to know the type of charge you're being arrested for. What is the name of the charge? And that way an attorney can figure out if it's a felony or not. And most importantly, you have to know where it happened. What was the law enforcement agency? All these calls that attorneys like me get after hours or on the weekend or even during the week, people, of course, don't know. what's going on. Why would you? You're not in the system. But if you can tell us the law enforcement agency or the place that happened and the type of arrest, just were you arrested for assault 4, assault 2, what was it? An attorney can likely figure out for you when you're going to have court, if you're going to have court, if your loved one's going to have court, all those type of things. And again, always go to that local attorney. Don't trust Lawyer Google. Lawyer Google is a bunch of generic stuff thrown out there by people trying to sell stuff, right? They're trying to scare you, and it is not specific. Criminal defense and criminal law is specific to actually the street it happened on, right? On one side of the street, it might be a city case. On the other side of the street, it might be a county case. Different court dates, different timings, different prosecutors, different situations. But if you have an idea how a criminal case is initiated, again, by an officer who either sends something to the prosecutor, or an officer who makes an arrest, or an officer who gives a citation, and then who makes the decision if there's an actual charge. If you can understand that, you're going to be much more well equipped to deal with a situation should it ever happen to you or a loved one, and I hope it never does. So if you found this video useful, please like and please subscribe. More people get the help they need. More importantly, if you've got a criminal problem in Washington State, you can feel free to give us a call. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.